Rounds 2 and 3. May I start with some introductory observations? So these two grounds concern claims that have been brought by several hundred claimants in their personal capacity as heirs of deceased persons. There are nearly 450 in that category, as well as a smaller but nevertheless significant number of claimants, totaling 105 claimants, who have brought claims expressly as representatives of the estates of deceased persons. We've already seen earlier an example of a so-called representative claim, and I just want to show you some examples of heirs claims in terms of how they appear. And if we go to the core bundle, tab 22 again, if we turn to Schedule A, 1A on page 332, let's pick up the first two items. Number 150 is an example of a representative claim.
Sorry, 150.
150.
So which page? I'm so sorry. I got tab 22 now.
Tab 22, page 332.
332. Sorry. Sorry.
Not at all. Yep. So row 150 is an example of a representative claim. And then, other than those claims or claimants who appear explicitly as a representative of an estate, all other claimants are simply identified by their name. And those are a combination of individuals who are not heirs and individuals who are heirs. So there's no distinction in terms of how the claimants are claiming, if I can put it that way, whether or not they are heirs or not, as the case may be.
Presumably, if this goes to trial, there will be master particulars of claim, but there'll also be schedules for each claimant showing what they're claiming.
Yes, there will be individual particulars of claim, and there has, unsurprisingly perhaps, been requests for information already passing between the parties as to which of the claimants are said to be heirs, understandably, and there's quite detailed probate data that has been provided on behalf of the claimants to the defendants. That material is not in the bundle. I don't think it matters for present purposes, or at least the detail of it doesn't matter. And in terms of how the master particulars of claim deals with the issue, you will see that at tab 25, paragraph 6 of the pleading on page 385 states that the claimants are all individuals, or in some cases, the heirs or representatives of the estates of such individuals, or in a small number of cases, legal entities, etc. But it's fair to say that so far as the master particulars of claim go, there's not much more information provided about that.
Can I just check on page 332? A number of the claimants have had amendments where originally it was a personal representative of the estate, and then that's been amended to say, instead of a personal representative, number 168, for example, represented by that person. What is that change of words meant to mean?
Which page are you on, my lord? I'm so sorry.
You were looking at 150.
Yes.
Well, it's the same with 150 and 168. It began as personal representative, and then it became represented by. And I just wondered what the significance of personal representative being substituted with the words represented by is, or if there's no significance.
That's not clear to me at the moment. It may simply be that it's an amendment that's been made so as to ensure consistency in the way in which the representative claims were presented.
But it's not meant to signal any change other than that this is a person acting on behalf of the deceased.
Correct. Yes. So the key point, at least for present purposes, is that the heirs claim in their own name and right, and not in a representative capacity, just like other individual claimants who are not heirs claim in their own name and right. The defendants have categorized the claims by claimants who are heirs as heirs claims, and the claims that are brought by claimants expressly as representatives of the estates of deceased persons as representatives claims, and I think that's a very useful shorthand that I'll adopt. And the issue of absence of English grants of representation affect both heirs claims and representative claims. Now, our argument before the judge below, in a nutshell, was that no grants of representation are required in respect of either category of claim for the following reasons.
Just sorry, start on this. I understand who heirs are. There's a list of which next of kin qualify as heirs under Brazilian law, widow and children and so on. What is a representative in this capacity, in this context? When you say the estate represented by heirs, what does that mean?
Well, there is a.
It clearly doesn't mean that they've got letters of representation
No.
in England.
No.
There is no equivalent of grant of probate, as I understand it, or grant of letters of administration in Brazil. So what does it mean to say? It just means someone claiming to represent, or does it mean one of the heirs who has been chosen to represent? What does it mean?
There is a procedure whereby an individual can apply to be appointed as effectively a state administrator, who is referred to as an inventariante. Inventariante. I don't believe that these individuals claim to be inventariantes. Some of them may be, others may not be. And I think so far as the language of the claim form is concerned, the term personal representative has been adopted, I believe, without any specific legal connotation, but as a generic term to indicate that those individuals are claiming on behalf.
They're asserting claims on behalf of the estate.
Exactly.
Without any particular, it's not an assertion of any particular status under Brazilian law.
Correct. At least it was not intrinsically intended to be a representation that those individuals have been clothed with authority under Brazilian law to represent the estate. Yeah. As I say, I can't rule out the possibility that some of them may in fact be clothed with such authority as an inventariant, but I don't believe that that's the case for all of them. That particular issue, I'll explain why in a moment, does not matter, in the sense that I entirely accept that if the status of those individuals were to remain, as stated, personal representatives, they cannot maintain those claims as such, whatever the meaning in law, whether Brazilian law, English law, or whatever other system of law one might care to apply to it, that term might mean under that relevant system of law. It doesn't matter because the way in which we presented the argument to the judge is that the heirs claims are asserted in the names and in the right, personal names and right of the individuals. The representative claims we accept cannot be maintained without letters of representation, but all of the representative claimants are heirs.
Can I just try to understand it a bit more? I mean, there's a distinction in terms of the pleading between your heirs claims and your representative claims. Is there any other distinction? I mean, is there an underlying distinction? I mean, assuming that these individuals have not been clothed, then they are just claiming in the same way as heirs, aren't they?
Correct. And that is why that is one of the points that we made to the judge, which is that our position is all of those so-called representative claimants are also, in fact, heirs. And so if we're right...
When you say also, I mean, are they claiming in any other capacity? I mean, they seem to be...
Yes, you're right.
They seem to be, the two classes seem to be the same sorts of person. They are heirs claiming pursuant to the Brazilian procedure.
Yes.
And some of them may possibly be clothed with something else, but you've got no particular reason to believe any individual is.
Yes, you're absolutely right. And again, it's a case of what happened perhaps with my loose terminology when we were dealing with the nullity principle earlier. And you're right that if as I accept, the status of personal representative for present purposes has really got no real content or no meaningful content, then essentially what we're dealing with is claimants who are, as it happens, all heirs, but in 105 cases, they have been described in the way that they have. But my submission is that the resolution of the question of principle, whether an heir who claims to be entitled to assert the cause of action in his own name and in his own right on the basis that he is now the new owner of that asset by virtue of the Sezin principle, the resolution of that problem ought to provide an answer as to the appropriate treatment for all such claims, irrespective of the explicit words of representation that may appear in about a quarter of those cases.
When you say heir, do we know anything? Is it a share? He's one of 4 siblings, or is he sole heir? Or
Well, this is where you have a number of permutations. Within the 1,550 odd claimants, there are sole heirs. I can't give you precise figures, but there are sole heirs. There are also cohorts of or situations where all of the co-heirs of a particular deceased person are claiming, but there are also cases where only 1 or 2 out of more co-heirs might be claimants, but there may be some co-heirs that are not claimants. So you have all 3 permutations, as it were, and that, at least it does feature at one level of the argument, and I'll come to that in a moment. The judge's ruling, just so we're clear, was against the maintainability of heirs' claims and representatives' claims in the absence of English grants of representation in relation to the recovery of the losses of deceased persons. But the nature of orange farming in Brazil is such that several members of the same family will often have their own individual interests in the relevant farm, so that an heir may wish to recover compensation in respect of both the losses of a deceased person of whom they're an heir, as well as their own personal losses resulting from the alleged cartel activity. And as regards the recovery of personal losses, as distinct from the losses of deceased persons, the judge has ruled that heirs are entitled to bring claims in respect of their personal losses, and the defendants have not sought to appeal that ruling. So that ruling stands. The judge, however, has also ruled that the claimants who have brought representatives' claims, but have also suffered personal losses, are also entitled to claim in respect of their personal losses, notwithstanding their failure to obtain English grants. So from her perspective, perhaps reflecting in a way the irrelevance for present purposes of exactly how they've been described, if there's no particular meaningful status to be attributed to their description as being a personal representative, the judge treated, so far as personal losses are concerned, all of the claimants equally in terms of their ability to recover. But insofar where express words of representation do appear, the defendant's position is the judge was wrong and should have treated those claims as nullities and therefore incapable of being saved by amendment.
is this what's been called the carver? Or that?
Yes, exactly. That relates to the carve-out, the personal losses carve-out. Exactly.
So if you looked at your list on 332, if we look at number 150 again, would that be a situation where if the person concerned, Sanchez, was suing both his heir and also had personal losses because he owns 6 of the trees in the orange grove?
Yes.
Either way it works, the claim stands for the 6 trees that he owns, but not for the rest of the infringements that affect the rest of the heirs.
Effectively, that's the result of the judgment as it stands, yes.
So you just take that description and what do? You leave the description in, but you know that it only applies to a little bit of the losses that are claimed.
Yes, it wouldn't require an actual correction if a claimant is a valid claimant in respect of both categories of loss. It simply means that in the light of the judgment, that claimant would not be able to advance a claim in respect of the losses of the relevant deceased person.
Right. So are you metaphorically putting brackets around the words in 150 of the estate represented by, all of that goes, and then it's going to be Mr. De Nascimento's losses? Is that how it's intended to work, the carve-out?
Yes, it would be, well, ultimately, yes, it would just be the name of the person when the words of representation are removed. But that of itself obviously will not tell you what the losses are.
No, but
because
it means it must be losses for that person because there's now no reference to the estate.
Exactly,
Yeah.
yes.
That's
yes.
how it works.
It has been quite an intricate exercise to try to work out the consequences of the judgment. The parties took some time to try to agree that. And the number of permutations is more formidable than one might think at first glance. So I just wanted to say a few words about the position in relation to personal losses. But coming back to the substance of the appeal in relation to grounds 2 and 3, those grounds essentially originate from our argument that heirs of deceased persons are entitled under Brazilian law to pursue deceased persons' causes of action in their own names, effectively as the new owners of those claims, in accordance with the Sazine principle. And that argument naturally raises two questions. Because obviously any claimant coming to an English court can rely on whatever system of law he or she thinks may be applicable at the outset and present a claim. But obviously that may or may not be right. And the argument, therefore, that the heirs have advanced raises questions first as to whether the question of the heir's title to sue should be determined as a matter of Brazilian law or as the judge found as a matter of English law, question 1. And question 2, if Brazilian law is the applicable law, whether Brazilian law entitles the heirs to sue in their own names in any event. Obviously, if it's English law, we know what the answer is. The judge's given that. There's a lot of case law about that. And that's not in dispute per se. But what is in dispute is the question of characterization, which tells you what system of law, what conflict rule to apply, and hence what applicable law you might end up with. And secondly, even if it were Brazilian law, the judge found it doesn't make any difference either.
Well, you'll get to that under
Yes.
ground 3. I must admit, I'm not exactly clear how that all works, but let's leave that for the
Yes.
Now, be sure what you've just said. If it's English law, then all the consequences follow. Just be sure what it is you're accepting. That if the question of characterization,
Yes.
if the answer to the question of characterization is you have to look to English law, then under English law you can't pursue a claim on behalf of an estate in England unless you've got letters of administration in England.
Yes.
And none of these people do.
Yeah. Correct. That,
And then actually, I think 1 or 2 of them may have subsequently
3.
applied.
There were three so-called test cases, as it were, or I think that's how they've been described in correspondence. It's quite an involved process, as your lordships know, and obviously, given the very large number of claimants, pending the resolution of this argument, a number of applications were made. 3 applications were made, and the letters of representation were obtained. But I'll come on to that.
Actually, I don't think I do know how complicated the procedure it is. It's non-contentious privilege. You don't have to bring proceedings. You apply, presumably limited to this claim. There are no other. These orange farmers don't have any other English assets.
No, I may be overstating the level of complication. I don't pretend to know all of the details, but what I mean is it takes quite some time and it requires quite a lot of documents to be...
But if you have to do it for 500 people, I can see it. There's an exercise. But
Yes.
I'm not sure that I would automatically assume it's a difficult as opposed to a time-consuming exercise.
I wouldn't pretend. I wouldn't suggest that it is difficult. In fact, one of our arguments in relation to discretion under our grounds 4 and 5 is that, well, there's no reason to suppose that if we had to get letters of representation, we couldn't, which is relevant, arguably, to those grounds. But let me therefore start with, and forgive me if it's in a sense part of my own education as I've prepared the argument. If I start at a fairly basic level, but I think it's necessary because usually in conflicts cases there's no difficulty identifying the legal category that one is dealing with. Certainly in the commercial field, it's very rare. I think that since Macmillan and Rosana, where the question of characterization was looked at, as it were, in more fundamental terms or almost doctrinal terms, there are very few cases that are reported where the question of characterization requires, as it were, requires one to go back to first principles to try to understand
Maybe
exactly.
because most commercial cases are simply involved with contracts.
Contract and tort, or occasionally trust, and therefore the legal or restitution.
Family law used at least to throw up all these questions.
Right.
And property and succession and so on. Sure.
Well, indeed.
Many more difficulties, I think.
Absolutely, and indeed, it's perhaps no coincidence that a couple of the cases that have those problems are indeed type cases, and so that simply means that your lordships are far more familiar with this than I am. But may I nevertheless start with characterization, and obviously at the heart of ground 2 is a contest between what we say is the characterization of the question of the heir's title to sue, either as an issue of succession to shows as an action, as we contend, or as an issue of administration of the deceased estate, as the defendants contend and the judge agreed. And obviously that question, the resolution of that question is critical because different conflicts of laws rules apply depending upon the precise characterization of the issue. And the different conflicts of laws rules in turn point to different applicable laws. And none of this is controversial. And it's also not non-controversial that if the issue is characterized as one of succession, Dicey's Rule 164 will apply. And the succession to the movables of an intestate is governed by the law of his or her domicile at the time of his or her death. That applies to intangible movables, such as shows as an action, and that therefore the application of Dicey Rule 164 would, in this case, point to Brazilian law as the relevant law of succession. I'll just give you the references in relation to shows as an action being included within the concept of movable property. Halsbury's Laws, paragraph 19-676. I don't think that that's an issue, and Dicey Rule 164 is well known. But on the other hand, if the issue is characterized as one of administration, and I'm speaking at a high level at the moment, I'm not actually delving into the case law, I'll do that in a moment if I may. If the issue is characterized as one of administration, it's common ground that under English conflicts rules, in particular Dicey's Rule 158, as recently confirmed in my Lord Justice Newey's judgment in Jennison, the administration of a deceased estate is governed by the law of the country from which the personal representative derives his or her authority to collect the estate assets, so that if the collection by the personal representative is of assets in England, it is English law that determines the personal representative's authority to collect those assets. Of course, English law does not automatically recognize a foreign court's appointment of the personal representative, but requires an English grant of representation or at least a resealing of the foreign grant for a personal representative's authority to be recognized by the English court. Now, just briefly, in relation to the question of characterization, we say it's necessary to remind oneself of the basic principles, at least briefly, by reference first to Macmillan, which is in the bundle of authorities, tab 18.
Do you accept the prior question? Which law do I use when I'm trying to work out if it's succession or administration? Is it English law that I use when I'm trying to work out characterization or not?
An English court applies English rules of characterization.
Right, so so when I'm deciding if it's succession or administration, I'm asking as a matter of English law, would an English court categorize this as a matter of succession to shows in action or as a matter of administration of an estate?
Yes, but, and this is where, in my respectful submission, the danger lies, but English rules of characterization themselves, as we'll see in a moment, English rules of characterization warn against characterizing the issue that arises that would then, which is the anterior question before going on to choice of conflict rule and selection of proper law. English characterization principles warn against a narrow, an inflexible wedding, as it were, of categories by reference to English domestic law categories. That's an important point. The exercise of characterization is approached in an internationalist fashion. And I know that sounds a little perhaps academic, but perhaps I can show you the authorities first, because that's obviously an important aspect of the disagreement between the parties. So if you go to tab 18, volume 2, tab 18. This was a dispute as to the ownership of certain shares that had been charged. And I think we can pick it up very briefly in the head note. Facts don't matter for present purposes. Held dismissing the appeal on the preliminary issue that the rules of conflict of laws had to be directed at the issue of law in dispute rather than at the cause of action on which the plaintiff relied, that the disputed issue was whether the defendants were purchasers for value in good faith without notice of the plaintiff's claim so as to obtain a good title to the shares, that a question as to who had the better title to shares in a company was to be decided by the law of the place where the shares were situated, which was the place where the company was incorporated, unless, per two of the judges, the shares were negotiable instruments, and that accordingly in circumstances the issue as to who had the better title to the shares was to be determined by the law of New York. What is relevant for present purposes is the statement of principle in the judgment of Lord Justice Thornton and Lord Justice Ord, and it's that the first starts at page 596, letter G. In any case which involves a foreign element, it may prove necessary to decide what system of law is to be applied, either to the case as a whole, or to a particular issue or issues. Mr. Oliver from Macmillan Inc. has referred to that as the proper law, but I would reserve that expression for other purposes, such as the proper law of a contract. Conflict lawyers speak of the lex causae when referring to the system of law to be applied. For those who learn Latin in favour of English, one could call it the law applicable to the suit or issue, or simply the applicable law. In finding the lex causae, there are three stages. First, it is necessary to characterize the issue that is before the court. Is it, for example, about the formal validity of a marriage, or intestate succession to movable property, or interpretation of a contract? The second stage is to select, so in other words, the stage after characterization has been effected. The second stage is to select the rule of conflict of laws, which lays down a connecting factor for the issue in question. Thus, the formal validity of a marriage is to be determined for the most part by the law of the place where it is celebrated, intestate succession, the movables, the law of the place where the deceased was domiciled when he died, and the interpretation of a contract by what is described as its proper law. Thirdly, it is necessary to identify the system of law which is tied by the connecting factor found in stage 2 to the issue characterized in stage 1. Sometimes this will present little difficulty, though I suppose that even a marriage may now be celebrated on an international video link. The choice of the proper law of the contract, on the other hand, may be controversial. In an ideal world, the answers obtained in these 3 stages would be the same in whatever country they were determined, but unfortunately the conflict rules are by no means the same in all systems of law. In those circumstances, a choice of conflict rule may have to be made. It is clear that in general the 2nd and 3rd stages are to be determined by the law of the place where the trial takes place, the lex fori. That law must tell, 1, what the connecting factor is for the issue before the court, and what system of law it points to. But the first stage, characterization of the issue, presents more of a problem. And then there's a passage from Dicey and Morris. You will note, interestingly, at letter C, Lord Justice Staunton does not appear to think that the first stage, the characterization stage, is necessarily something that is to be done by reference to the lex fori, or at least he kind of leaves that open when he goes on to say, but the first stage, characterization of the issue, presents more of a problem. But you'll see something rather more specific in Lord Justice Ord's judgment in a moment about that particular point. And after citing from Dicey and Morris, just above letter G, later at page 47, quote from Dicey, the way lies open for the courts to seek common sense solutions based on practical considerations. And then you can see what he said, letters G to H. And right at the end, we must do our best to arrive at a sensible and practical result. Obviously that statement of itself might be said not to be particularly illuminating, but nevertheless, the need for common sense definitely prevails. And then at page 612 of the bundle, this is in the judgment of Lord Justice Ord, at 407, at letter B, subject to what I shall say in a moment, characterization or classification is governed by the lex fori, but characterization or classification of what? It follows from what I have said, the proper approach is to look beyond the formulation of the claim and to identify, according to the lex fori, the true issue or issues thrown up by the claim and defense. This requires a parallel exercise in classification of the relevant rule of law. However, classification of an issue and rule of law for this purpose, the underlying principle of which is to strive for comity between competing legal systems, should not be constrained by particular notions or distinctions of the domestic law of the lex fori or that of the competing system of law, which may have no counterpart in the other system. Nor should the issue be defined too narrowly, so that it attracts a particular domestic rule under the lex fori, which may not be applicable under the other system. The dispute about the nature of the issue in this case, whether it is about restitution, stemming from the developing notion of a receipt-based restitutionary claim, or about property, is a good example of the danger of looking at the problem through domestic eyes. And then there's a reference to case law on restitution. And if you then pick it up at letter G, the paragraph beginning, the receipt-based restitutionary claim is a notion of English domestic law that may not have a counterpart in many other legal systems, and is one that it may not be appropriate to translate into the English law of conflict. And then just for completeness, although it doesn't really add anything to the 2 more substantial passages that we've just seen, page 622, judgment of Lord Justice Ord's letter G under the heading characterization. As appears from the 2nd chapter of Dicey and Morris, the problem of characterizing which judicial concept or category is appropriate is not easy, but it is a task which is essential for the court to complete before it can go on to decide which system of law is to be used to decide the question in issue. In this case, the court's task is made easier as the parties are agreed the characterization of the issues to be determined according to English law. And then if we go further on in the bundle, tab 20, this is Rosana. And this was a rather complex marine claim, but the key dispute it gave rise to can be seen from paragraph 1 of the disposition headnote at the top of page 642, letters A to B. I could ask you to just glance at that passage. There was significant debate between the parties as to how to characterize the issue before the court, and consequently which particular conflicts rules to apply to the issue. Lord Justice Mans's speech illustrates that. If you pick it up at paragraph 18 on page 653, this is referring to what the judge at first instance did. Mr. Justice Longmore started by seeking to characterize the issues. His initial analysis suggested that the issues arising from claims 1 and 4 were contractual, while those arising from claims 2 and 3 were proprietary. But he concluded that the real question was whether RZ could invoke, as against the insurers, the assignment to them of the contract of insurance. On that basis, in his view, Article 12.2 of the Rome Convention, as scheduled to the Contract Applicables Law Act 1990, provided the key to identification of the applicable law. English law governing the contract of insurance was thus the law by which to determine whether RZB had a good claim against the insurers. And then you can see the judge goes on to say, at the beginning of paragraph 19, I turn to the opposing analysis of the issue. At the beginning of paragraph 20, these opposing analyses both assume that the factual complex weighs as only one issue, and in their differing identification of that issue emphasize different aspects of the facts. And then a little above, just below letter E, between letter E and letter F, the first issue for consideration raised by the parties opposing cases is whether, in the light of the assignment and notice, and apart from any attachment, the right or title to such claim and sums as against the insurers was and is in RZB or 5-star or both. This is an issue concerning the effect on insurers' liability under the contract of insurance of 5 stars voluntary assignment to RZB. And then at paragraph 25, the judge says, I turn to the first issue. Have already been stated. They throw up a choice between the proper law of the insurance and the lex situs of the insurance claim. But a proper legal analysis cannot depend exclusively upon the legal systems for which two parties happen to contend in their own partisan interests. The jurisprudential and academic material which we have, which we've been shown, indicates the existence of other possible candidates, such as the law of the assignment's place of residence or business, and the law governing the contract of assignment, which may need to be kept in mind. And then paragraph 26. Both parties accept that at common law, the identification of the appropriate law may be viewed as involving a 3-stage process, and then a quotation from Macmillan. The process falls to be undertaken in a broad internationalist spirit in accordance with the principles of conflict of laws of the Forum, here England. Obviously, the reference there to broad internationalist spirit is undoubtedly a reference to Lord Justice Ord's caution or warning against adopting too narrow domestic, purely domestic legal notions when seeking to characterize. While it is convenient to identify this 3-stage process, it does not follow that courts at the first stage can or should ignore the effect at the second stage of characterizing an issue in a particular way. The overall aim is to identify the most appropriate law to govern a particular issue. The classes or categories of issue, which the law recognizes at the first stage, are man-made, not natural. They have no inherent value beyond their purpose in assisting to select the most appropriate law. The mechanistic application without regard to consequences would conflict with the purpose for which they were conceived. They may require redefinition or modification, or new categories may have to be recognized accompanied by new rules. As stage 2 if this is necessary to achieve the overall aim of identifying the most appropriate law. And then 28, the three-stage process identified by Lord Justice Thornton cannot therefore be pursued by taking each step in turn and in isolation. And then a quotation from Lord Justice Ward's speech in Macmillan, including the warning about not being constrained by particular notions or distinctions of the domestic law of the lex fori. And then 29, there is in effect an element of interplay or even circularity in the three-stage process identified by Lord Justice Thornton. But the conflict of laws does not depend, like a game or even an election, upon the application of rigid rules, but upon a search for appropriate principles to meet particular situations. And so what we say is clear from these two authorities is, first, that what is to be characterized is the particular issue of law to be determined by the court. This, of course, requires looking at what claims are being made and what defences are being deployed, but the court is not bound by the manner in which the parties have chosen to frame their own arguments. The court is looking at the broader picture to try to identify the real issue that arises between them. Secondly, the process of characterization, at least so far as Lord Justice Ord is concerned, is governed by the lex fori, but subject to the important qualification that the underlying principle of characterization is to strive for comity between competing legal systems, and the exercise must therefore not be constrained by particular notions or distinctions of the domestic law of the lex fori, or for that matter, the particular notions or distinctions of the competing system of law. There is a need for the exercise to be based on common sense and practical considerations so as to arrive at a sensible, practical result. There is an element of interplay between the three stages, and they should not therefore be addressed in isolation. And the overall aim of that three-stage process is to identify the most appropriate law to govern the particular issue. And the exercise is to be undertaken in a broad internationalist spirit. Now, what I want to do next is essentially, if we're unconstrained by the particular case law that the parties have relied on, which deal with particular factual situations, let's leave that aside for the moment. We'll come back to that. But if we're unconstrained by that, and we're simply doing our best to apply the principles we've just read to the facts of our case, we say you find the following. Relying on the Sazine principle under Brazilian law, the heirs claim to be the owners of the deceased person's causes of action and to be entitled to sue in their own name and right in respect to the losses of those persons. At this stage of characterization, the court is not concerned with the validity of that claim, nor indeed with the precise content of the Sazine principle.
What do you mean by validity of the claim?
Whether it's a good claim, whether, for example, they are in fact an heir on the facts, whether Brazilian law does.
Whether their claim is to be entitled to sue is a good claim under Brazilian law.
Even under Brazilian law, yes, on its merits. At the stage of characterization, the court is not concerned with those questions, nor indeed with the precise content of the Sazine principle. Nor indeed does it have to assume.
Hang on, what? Nor indeed with the precise content of the Sazine principle. In what sense do you mean that?
In other words, the court at the characterization stage doesn't need to know the full detail of exactly what the Sazine principle is, how it, and all of its intricacies.
I mean, you're obviously going to develop these points, but
yes.
I'm not quite sure why not.
Well, obviously,
I mean, if as I think is recognised, there is a distinction between, for characterisation purposes, between administration on the one hand and succession on the other. You do have to understand the Sazine principle a bit, don't you, to work out whether it's a succession principle.
well, you certainly have to understand. You do have to understand at least an element of it, insofar as it allows you or helps you to characterize the nature of the claim that is being advanced and the resulting issue or dispute between the parties. Yes, I agree with that. And if I've made a submission that was suggesting that you don't even need to try to understand that, then I went too far. But what I'm saying is you don't need to go further than that. So you don't need, for example, to understand, let us say, precisely, let us say, when a distribution of the assets needs to be made between the co-owners who have become universal successors to the assets. You don't need to know that kind of detail because it's not really going to assist you in identifying the relevant issue.
It depends what you mean by, I mean, you don't need to know when in any particular case that might or might not take place. But the fact that it is a feature of the system
Yes.
is something to be borne in mind when doing the characterization.
Yes, I entirely accept that. And obviously, as I articulated the first point, which is that the heirs, in reliance upon the Saysian principle, claim to be the owners of the causes of action and claim to be entitled to sue in their own names. Obviously, at least that element of the Saysian principle is relevant in terms of explaining why they are claiming in that way. But my point at the moment is really that we don't need to know necessarily whether this is right, because one is concerned at the moment with identifying what issue arises between the parties. Parties at the outset of a dispute could have deeply flawed views of their rights under the relevant system of law and may make all kinds of claims that may or may not be justified under the applicable law. The claims may not be justified because they've got the wrong applicable law in terms of how they formulated the claim. The claim may not be right because they have chosen the right applicable law, but they've got it wrong as to what it means. All of that could arise. But in terms of characterization and the identification of the issue that arises in the sense of the dispute that's arisen, so for example, about the formal validity of a marriage, one party may say, well, we were married under Russian law. Another party may say, well, we were married under Ukrainian law, and each may have their case about that. And that could be quite intricate. They could both be wrong. But when you are characterizing the issue for the purposes of deciding, well, which system of law applies in the first place, you don't necessarily need to know all of the details of Russian law on marriage and all of the details of Ukrainian law on marriage. What you may be able to tell without that baggage is that the dispute between the parties is, for instance, about the validity of the marriage or about the date of the effective date of the marriage or whatever else it may be that the dispute between the parties might throw up. So that's the point I'm making at the moment. I entirely accept that necessarily in the real world, one will have some kind of notion of what may or may not be the case under one system of law as opposed to another. But the characterization point itself, just as in a sense reinforced by the point that the party's own formulation of their claim is not necessarily determinative, the characterization issue is first and foremost about the correct or the best classification you can find of the judicial category or legal category you're dealing with, because only then you've got to start somewhere, as it were, and only then can you move on to the conflict rule that best seems to apply to that type of category. So that's why I say the detailed content of the Saysian principle or Brazilian law, it does not necessarily matter for this purpose.
Can I just ask, you're talking here about the characterization of the relevant issue at stage one, and your first submission is that relying on Brazilian law, heirs are entitled to sue. But leaving aside all of those things at a high level, why isn't the relevant issue quite simply who is entitled to bring and enforce a claim for injury suffered by a person now deceased as a result of injury inflicted on him in breach of competition laws? Why isn't that the issue? Who is entitled to bring a claim for injury to another person inflicted by a breach of competition law?
Well, the issue, in my respectful submission, has to be looked at in the light of what the claim is. It's not determinative, but what the claim is in this case, the heirs purport, rightly or wrongly, they purport to claim as any other claimant in their own name, as if they own the cause of action. That is what they purport to do.
I mean, just picking up my lord's point. So suppose you had, under a system of law, a situation where a deceased person had a claim and that claim passed to someone who we might describe as an heir, absolutely, no strings attached, it's their property out and out.
Yes.
Now, at that stage, I don't think it could be suggested that you'd characterise a claim that the heir then brought as a matter of administration. You'd pass beyond that to succession or whatever.
Forgive me, just stopping there. I mean, of course, if you look at this process through English eyes, that would not be succession. And from an English perspective, no matter what the law of the domicile of the deceased might say in that respect, which is what you're assuming to be the applicable law, through English eyes, none of that matters, unless you're able to characterize the issue as an issue of succession. And only then would you look at the law of the domicile. But if you characterize the issue for
I'm not sure why I'd characterise it as an issue of administration.
Well, I agree with you. I certainly agree, and in a sense, that is the debate, or certainly the argument that we're raising, which is that if we take, of course, there's a debate in the case as to exactly what the effect of Brazilian law is. I entirely accept that, and obviously that's covered in ground 3, and that's why also I was making the point that at the characterization stage, it doesn't matter who's right or who's wrong exactly as to exactly what is contained within Brazilian law. If you look at how the claimants are advancing the claim, there is no distinction between how heirs and non-heir claimants are advancing their claims. They are both, in both cases, advancing their claims in their own names in respect of the losses pleaded, and without any, if we ignore the words of representation, because that's a special category, but so far as the heirs are concerned, not in a representative capacity. There is nothing to suggest that the heirs are claiming on behalf of anyone other than themselves.
I mean, the difficulty is that I wonder how much room for debate there really is over the Brazilian law. I mean, the judge has set out what the Brazilian law is. I'm not sure how far that's really an issue. I mean, the position is doubtless the heirs are claiming because they want to get benefits for themselves, but they don't, putting it non-technically, have an out-and-out interest in the claims because they don't necessarily get to keep the fruits of them. They're shared out, potentially. So the question is, does that matter?
Well, number one, we don't accept all that the judge has found in relation to Brazilian law, and I'll give you a because you just so you understand where we're going. Brazilian law is very clear that upon death, immediately and automatically, all ownership vests
in all the heirs.
To the heirs.
All of them.
All the heirs.
All of the heirs, absolutely.
Yeah, not one heir alone, unless there's
Well,
only
if
one.
there's only one, it vests
There's only
in
one.
that.
Leave him or her aside. There's only one. He or she's quits in.
Yes.
But if there's 2 siblings or
Yes.
3 siblings in a Brazilian family, they have a share in the estate when it's finally divvied up.
Well, no. Before that.
I mean, they may, in the
that.
meantime, each of them, in some sense, have a claim to all of it.
They have
Just
yes,
as
they are
joint tenants have a
I mean,
claim to, but
they are joint owners. So together they are the co-owners together, or the co-heirs together, own the whole thing, and they have effectively, until the sharing takes place, the formal sharing, the so-called issue of the formal de partida, what they call the FDP, until that moment, which is the moment of individualization of the shares, they have a share in the undivided whole. But their ownership is in relation to the whole.
Let's test it by a situation where you have 3 co-heirs.
Yeah.
And we have a situation where only one of those co-heirs is a party to the claim in England. So the
Yes.
other 2 heirs are not.
Yes.
Is that person enforcing his right? And if so, right to what?
He is enforcing, under Brazilian law, pursuant to the regime of co-ownership, each and every joint owner has the right to enforce his or her right.
But he's not just enforcing it to get his share, he's enforcing it to get the claim for all of the heirs, isn't he?
That is correct, but that is only because until there is a sharing, he can only enforce the entire right. He hasn't got an individualized part. He therefore necessarily has to enforce the entire right, and he would have ultimately to account for the proceeds so that eventually they are shared. But the point is, the cause of action, the right to sue, is a right that he absolutely has, irrespective of, for example, whether the co-heirs agree or don't agree with the fact that he's taking action. And that's one of the pieces of evidence, for example, that our expert gave. In effect, the only credible witness who gave evidence, expert witness who gave evidence at trial, as found by the judge, was Professor Schrank. And one of the important points that Professor Schrank makes, and I'll obviously have to take you to that in due course, is that that as what he described as a reflex action, the heir, unless and until there has been an actual sharing in the sense of an individualization of each co-heir's share, necessarily only has part ownership of the whole, and therefore has to take action that is directed to the whole. But that process, or that right that he has, is his right in his own name. It's an absolute right that is not qualified by what other joint owners agree or don't agree with. But the only feature, and it relates to the asset as a whole, because there is as yet no individualization. It can't be said, well, obviously in the case of a cause of action, how do you chop up a cause of action in any event? But if it's a house, for example, under Article 1314, he can take all action that would be open to an actual owner in relation to the whole house.
And although you say we don't need to know what the principle of safety is, don't I need to know, and don't I need to test whether or not somebody who claims to be an heir is an heir? If they turn up and say, I'm the granddaughter, but don't worry, my aunts and uncles are all dead, don't I need to know?
Not at the point of characterization. At the point of characterization, the court doesn't try to... So, for example, as we saw in Raiffeisen, one party was saying, well, this is an issue as to whether the sale was to a bona fide party acting in a bona fide party who gave consideration without notice. Now, the court doesn't go about asking, well, is that even correct, that claim? Because were they in fact bona fide? Was there in fact notice?
The reason why I put the question is this. If you're right, then anybody can claim to be an heir, because we don't check whether or not they're entitled to be an heir. And anybody can bring the action in England. But you might think that the purpose of, or the relevant issue is, who's allowed to collect up for future distribution the money in this claim so that the heirs can get it. And that may sound as if you're looking for identifying who is properly authorised to be the collector, if you like, of the assets that will be eventually divvied up.
But
Would you
that in
like
my,
that?
yeah, I understand that, and obviously that is what the other side say and what the judge thought was the position. But that in my respectful submission, completely fails to recognise that the heirs are purporting to exercise, rightly or wrongly, they are purporting to exercise a personal right of their own that they claim to have inherited, as if they were the owners of the cause of action, and are claiming to sue in the same manner as the deceased persons would have sued had they remained alive. That is how the claims are brought. And so when, obviously, if you take the representative claims, for example, I mean, let's contrast the position where an heir simply presents himself as an individual claimant in his own right. Take the case of a representative claimant. Of course, in the case of a representative claimant, where the claimant said, well, I am authorized to represent the estate, and the defendant says, rubbish, you're not. It's not difficult to find that, I don't think anybody would disagree in that situation, that the issue, obviously, in that case, is whether the claimant is authorized to represent the estate. And the issue is thus, in that case, because the issue ultimately, although it's not entirely blind to realities, the issue is obviously first and foremost framed by reference to the claim and the defense. But if the claim is that although one might, it's inconvenient perhaps to consider the case of the sole heir. Consider that case, because that's the way to test it. If a claimant is claiming as a sole heir, and there's nobody else, and that is how he's claiming, he's not claiming in this case any differently from any other heir. Yet in his case, one would have no difficulty saying, well, if that is the claim and that's being disputed and that's the issue for the court, obviously the question for the court is whether that claimant has an entitlement as owner of the cause of action to sue in the same way that the deceased person could have sued if he'd remained alive. And it wouldn't be very difficult in my respectful submission, just as Lord Justice Newey gave what certainly his lordship appeared to consider to be an obvious case for characterizing the issue as one of succession. That would clearly be a case of characterization of succession. So the only question, therefore, is, well, what does it matter? Why does it matter that in a particular, in the majority of the cases, we have 2 heirs or 3 heirs or 4 heirs, when they are all claiming in the same way and no differently? And at the moment, we're not debating whether the claim is right. We're only dealing with the characterization.
And I'm a bit worried by slowing you up, but can I just check one thing? In the case of a sole heir under Brazilian law, is there a sharing stage? How does it work? You still have your, I've forgotten what it's called, an FTP or whatever later on, do you? Or
I'm not sure off the top of my head, I'm afraid. No. I think that's something I'll have to check, if I may. But I'm afraid I don't recall off the top of my head what the position is in that situation. It may well be that formally there is such a stage, but obviously there would never be any doubt as to who the beneficiary would be. And there may, obviously there would be no particular issue as to the individualization process. So, my lords, may I think I've effectively, made the point, and it's a very simple one at the end of the day, that the heirs are not, if you ignore the special category of the representative claims, which we know don't mean anything in a way, and which can be amended in any event by deleting the words of representation, the heirs are claiming like any other claimant in their own right, as if they own the causes of action. And if that is what is at issue in the case, why is that not a question of succession? I.e., Well, are you the owner of the owner? Are you the owner of the causes of action, or are you not? Or are you some imposter who is not in the owner
Just to
of the
confuse the
causes of
issue for a moment, suppose you have a personal representative appointed under the law of another Commonwealth country, therefore presumably the same as any personal representative here. Well, they will own the property and they will bring the claim in their own name.
But with a critical difference, which is that their ownership or their title is representative title.
Well, in a sense, but my recollection is you don't get a trust at that stage.
No, but they are certainly not a beneficial owner.
No, well,
They can't just
no.
run off and say.
I thought personal representatives had the entire legal and beneficial interest vested in them, and all that the beneficiaries under a will have is a right to due administration. Commissioner for Stamp Duties in Queensland.
Well, well,
And that's why you bring a devastavius, isn't it, rather than breach of trust claim.
well, that may be so, but the point is, it is not the same thing as full beneficial ownership with, as it were, without any duties, whether statutory, equitable, or otherwise, that are attached.
So if the heir under Brazilian law walks off with the proceeds of the claim and keeps them all for himself, are there any strings attached? Can he not be subject to a claim by the other heirs?
Well, there are some duties attached. I accept that in relation to the fruits of the action. But what we're talking about at the moment is the exercise of the right of suit in relation to the causes of action themselves, which by law will automatically and universally have transferred to the heirs without any other legal step. They are, whereas previously Mr. X.
Well, if you're named as executor under a will, well, you automatically get title.
Well, I am not disputing that, but what you find in all of the cases, and this is where in a sense one must test all of these propositions ultimately by reference to the particular factual scenarios in the cases, what you find in all of the cases, like Jennison, Jennison itself, of course, was a case where what was in issue was the authority of the relevant individual to represent the estate. All the cases on executors and administrators are all cases where what was in issue essentially was, although the language of title to sue is referred to generally, they are all cases of representative title, if I can put it that way. They're not cases where the ownership, the fundamental ownership of the assets itself is an issue. What is an issue is the authority of the relevant individual to represent the estate. And one can obviously see in that context that it's an issue that relates to the administration of the estate.
Can I ask you something else?
Yeah.
One of the points taken in the skeletons is this claim that you have brought in England an English asset?
Yes.
Mr. Kennelly says it's a chosen action, that's not in dispute. The situs of a chosen action depends on where you can sue for it. Once you sue for it in England, you've reduced it into possession in England. It's therefore an English asset.
Yes.
If somebody dies in Brazil owning an English house, can the heir claim it? Or do they have to take out a grant in England before they can get onto the register in England?
Well, in my respectful submission, the situs issue in relation to chosen action does not itself answer the characterization question, because the characterization question, at least conceptually, arises even before the claim is started. If you ask yourself, well, before this claim was started in 2019, all of these causes of action are supposed to have accrued. I mean, leaving aside the question of knowledge, back in over the year 1999 to 2006, at a time when, let us say, Mr. Cutrale or the defendants were domiciled in Brazil. From a succession point of view, in terms of how the Sazine principle works, whatever claims might have existed under Brazilian antitrust law against those individuals obviously would have transferred to the heirs of deceased persons. And,
No, I understand that.
and
So,
yes.
but my question was designed to illustrate a question where there is no doubt that an asset is an English asset. There's no doubt it belonged to a Brazilian domiciled owner whose name was on the register. If he dies leaving an heir, you tell us, and I don't think it's disputed, but under Brazilian law, ownership passes to the Brazilian heirs collectively. Can they get on the register in England without an English grant?
Well, the answer to that, I think, would be that if they were to claim ownership of the house, and that point were disputed, and the matter came before an English court, the English court would have to face the very question we're now facing, which is whether that claim raises an issue of succession or is an issue of administration.
I would be quite surprised if you could get yourself onto the register of English registered property simply by saying, I'm the heir in Brazil, without taking any steps to establish your title in England through an English grant. I may be wrong, but I mean that is the same question.
Well, yeah, that may be simply stating your impression that perhaps it's more administration than succession. But presupposing for a moment to test whether the contrary conclusion would be absurd, let us suppose the conclusion were reached that the true issue thrown up by this dispute is an issue as to the ownership of...
You see, I'm not sure it is a question of ownership, it's a question of proof of title. And the whole point about a grant is it proves your title. And you can see that in the case of executors. Executors, take a case with no foreign element at all. An English executor derives their title from the will. So an executor can bring a claim the day after death. They can't succeed at trial or establishing a claim without probate, because the probate is the only evidence that will be accepted that what they claim to be the last will is in fact the true last will. So that's what the grant does. It doesn't in the case of an executor, it doesn't confer ownership, which derives from the will, but it proves title. And that's why I wonder whether you can, simply by saying, under my system of law, I'm now the owner, succeed in England without proving your title, or whether the only way you can prove your title is by getting an English grant, because that's the only evidence the English court, will recognise as proof of title.
Well, two points in relation to that. Number one, I think Lord Justice Newey will know far more about the distinction between the question of whether you acquire title and the question whether you how you prove title in the case of an executor appointed under a will. Because the point about proof of title by receipt of a grant is that it doesn't mean that your title is invalid. And in fact, in those cases, your action is not defective or ineffective from inception. You're entitled to carry on with your claim. It's simply that, but before judgment, you need to have obtained your grant. So it's a hybrid situation, and I think Lord Justice Newey considered that point in Jennison, which is obviously peculiar to the position of executors as opposed to that of administrators, where the proof of grant is itself an integral part of the conferment of title.
That's right, because the title to English assets of an intestate vests in the president. Well, it used to be the president of the family division. It's now something called the public trustee.
Yes, but the relevance of the point of that distinction, however, is that in the case you're talking about, where the grant only goes to the question of proof, if the issue in the case is whether you have title, as opposed to whether you can prove that you have title, the grant is irrelevant. So it's not therefore, with respect, to use that example as implying therefore that even in that kind of case, the grant is, as it were, essential. It is not essential to the acquisition of title. It is only a question of proof. And of course, one can understand that in the context of a case conducted in England, there may be certain rules about proof that may have to be observed by a litigant who chooses to come and litigate in England. But the point that I was making earlier is that to go back to your example about the house, the point I was making was that in a sense you're restating the question that we're having to answer. And what is more, as you know, there is case law whereby foreigners who have succeeded universally pursuant to, I think in the particular case, the French equivalent of the Sayzine principle, have been held by the court specifically not to require letters of administration because their title would be recognized pursuant to the lex domicilii. And you can see even in that case, at least in the case of one judge, the doubt that he entertained as to whether it should be treated as an issue of administration or as an issue of succession. But we'll see that when we look at the Vankelin case, which certainly has certainly stood the test of time in the sense that it's been treated as good law by Mr. Justice Slade in the Haji Yanu case and is cited as well in Cheshire North. But it's fair to say there are not many cases in this area. Certainly in relation to the question of in cases where a claimant claims to own the relevant asset and sues in that right. There aren't many cases like that. Most of the cases are cases about personal representatives of one kind or another, executors or administrators. And so it's a little, one in my respect, submission level has to approach these cases with an element of caution.
I do see the way you put it. At the same time, I mean, you referred earlier to having something practical or workable, whatever.
Yes.
Well, maybe there aren't many cases because people have sort of proceeded on the practical and workable basis that if you're going to bring a claim here, you need to get a grant here. Well,
that may or may not be so. I have to say, in all the cases that have been reported, there are truly cases where it's the administrator who is taking charge, rather than there being a claimant who has a cause of action that he or she wants to enforce.
And I see that, but the Sayzine that we're concerned with is the sort of thing you find very often in civil law countries, isn't it?
Yes.
So there must be very many cases where you have people in a comparable position to your clients.
Well, I would be. I am sure that there is a lot of succession that goes on in civil law jurisdictions. I have no doubt about it. But yes, I certainly can't offer any specific explanation why it is that we only have Vankelin to speak on this point. But there we are. So
yeah.
Perhaps I can.
Yes, do.
I think I've really made my main point, and I think perhaps we ought to look at the case law. So perhaps I can start with well, perhaps I can just take you briefly to the judgment itself in terms of how the judge dealt with it. is paragraph 170. So rather than proceed in the way we suggest, if you look at paragraph 170, having recorded our submission at paragraph 170 and 171, she then goes on to observe at 173 that she accepts the submission for the defendant that the question of characterization is a question for the lex fori, the lex fori being English law, and thus it is a question of English law whether this is a succession issue or an administration issue. And in my respectful submission, whilst it's clear that characterization is obviously being done by an English court and therefore is done in accordance with English characterization principles, that obviously overlooked the point that I emphasized already, which is the warning against a narrow approach to characterization, which is inflexibly wedded, as it were, to purely domestic notions of the lex fori. And the judge's error in our respectful submission in that respect is particularly evident in paragraphs 175 to 180. In particular, where she quotes, for instance, in paragraph 180, where she quotes from High Commissioner of Pakistan, paragraph 28 on page 246. That argument, it seems to me, is not sustainable on the basis of authority, which is both clear and binding on me. Under the English conflict of laws, the stage of administration of an estate is governed by the law of the place where the assets are situated, which in the current context means England. Procedural questions arising in the administration of life are governed by the law of the place where the administration is taking place. It is only when one gets onto the question of succession and who is entitled beneficially to share in the estate that one looks to the law of the domicile of the deceased, where one is concerned, as here, with personal property. And you see a similar point at paragraph 185 of the judgment, where she says, however, it is clear from Pakistan that as a matter of English law, the automatic transfer under the principle of saisine is not recognized as succession. And so because, as she says, the saisine principle is not recognized as succession under English law, the judge felt compelled to conclude that the issue of the heirs' personal entitlement to sue as the new owners of the cause of action had to be characterized as an issue of administration of the deceased estate. But that, we say, was a non sequitur, because at the anterior stage of characterizing the relevant issue, the court is not constrained by purely domestic legal notions of succession and administration under English law. And it can and should take account of any foreign law notions that may be at play for the purpose of identifying the real issue in dispute between the parties.
How do you do that? We know that you've got a category of succession, we know you've got a category of administration. You say in assessing the scope of those categories, you take account of what? International ideas of administration, international ideas of succession?
Well, no, you take account of the fact that in very broad terms, under the saisine principle, there is a universal transfer of ownership.
But that's a question of how you apply the characterization. In terms of identifying the categories at the start, why should you look to Brazil? I mean, if you start off with an English idea, you say, well, you can't approach it on a narrow domestic basis, you have to look internationally. Well, where to find out what the notion of administration is and what the notion of succession is?
Well, you can do it. You can do it by a process of elimination. So, for example, what we know is that English law, administration under English law, is concerned with the representation of the estate. and the collection of assets on behalf of the estate. And you can ask yourself, well, is the assertion of the heirs' entitlement to sue as the owners of the causes of action, is that an assertion of representation of the estate?
Well, that's
one
different.
For a group of co-heirs, it sounds awfully like action for the estate as a whole. I mean, I know you say he's got an ownership and it's different and it can't be realised until they've got the money and they divide it between three of them. But even if he's succeeded to the shows in action, he hasn't succeeded entirely to the shows in action. He's still got to act to get it in, to be distributed to everybody, doesn't he? So if we're not tied to laws and we're looking at broader concepts emerging from some kind of holistic international zeitgeist, it sounds awfully similar, doesn't it?
Well, at the end of the day, it's just obviously the question of classification can be difficult and it can be quite impressionistic.
And can I just go back to that prior stage? Once you've decided what your categories are, you then have to look at the individual situation to find out whether that situation fits into a category.
Yes.
But you're saying, well, when you're deciding what your categories are, you have to take account of something other than English law. Well, what in this context?
You take account of the legal concepts at issue. So,
well, that won't quite do, will it? I mean, we can't judge what counts as administration for English law purposes and what counts as succession for English law purposes in terms of just fixing the categories by reference to what goes on in any particular country. So how do we find this international idea of what is administration and what is succession?
Well, you get those ideas by looking at what other legal notions or their equivalent exist in other competing legal systems, and you consider whether the competing systems of law that might be at play, how they categorize issues and what kind of notions they have.
And do we even know? I mean, do we know how Brazil or France or any other country classifies what goes on at any particular stage? Is there? Do the experts say that under Brazilian law this is characterised as succession rather than administration?
No, forgive me. I don't. What I mean by you can have regard to the foreign legal notions. I don't mean that you need to have regard to how they would characterize, because English law has its own characterization principles. But what I'm saying is English characterization principles do not operate on the basis that any issue that arises before an English court will be put by hook or by crook into an English category of one kind or another.
But it has to be, doesn't it?
Well,
I mean, you have to characterise before you apply your connecting factor. You have to find...
No, sorry, forgive me. What I mean is the way in which English law will do the characterisation is by having regard to the features of the foreign legal system. This is not particularly difficult. So, for example, in the case of universal succession, it's not very difficult for an English lawyer to understand that process.
Yeah.
I mean, certainly in the case of a sole heir, it's very straightforward. Okay, in the case of two or more, it becomes a bit more complicated. But the fundamental notion of an immediate transfer, frankly, it's no different from leaving aside the issue of representative title, as I've described it, it's no different from an executor being appointed under a will at one level. And English law has no difficulty at all with that. And in fact, in that kind of situation, English law itself looks to the foreign law for the validity of that transfer and gives effect to it if it is effective under that foreign law. So you might say it's quite a good example, in fact, that even in the field of representative title or representation, English law does not adopt a completely narrow domestic approach of simply ignoring whatever else goes on elsewhere. And one might say, well, why not? Why not? Well, why do we care? Well, an answer might be that English private international law generally does pay regard to comity between competing legal systems, and that there is an element of internationalism in one's approach, because at the end of the day, English law has an interest in as it were, integrating the international legal community and interacting in cross-border situations with other legal systems in a sensible, harmonious way, if possible. To go back to your point as to, well, how do we do it other than by reference strictly to English legal categories? We know that it's not to be done necessarily in accordance with strict domestic legal notions. We've seen that written.
Well, why should it be done in accordance with exclusively Brazilian notions then? I mean, you're taking the I want the Brazilian law succession category to apply, and you're treating that as both the categorization issue and the link. But why should Brazilian law, any more than English law or French law, be the law that determines it?
I'm
We've
not
got to choose between.
But that's the point. That's why I said, and forgive me if I didn't make myself clear. That's why I said at the outset, when I was describing characterization and I was describing the process of identifying the key issue that's thrown up by the dispute, that it's not necessary at that stage to understand the intricacies of the foreign system in all its gory detail, nor indeed is it necessary to understand whether or not the claim is correct. What you're concerned with at that stage is what the claim is, or what the argument is, and there is a counter-argument against it. And as a result of the interaction of that, you identify the issue that provides you with a legal category that then allows you to select an appropriate conflict rule under English conflicts of laws rules, because you've got to start somewhere. What that means effectively, and as I said as well, every dispute will usually, I mean, if it's a rational claimant, every claimant in every case will make an assumption as to what it says its proper law should be, or the applicable law is in relation to the cause of action. That judgment may be wrong, but that is how a dispute will usually start. And so you can therefore, you obviously have to use that as the background that gives rise to the claim and hence the issue that the court has to decide, which effectively means that you could have a situation where the claimant believes his claim is governed by Brazilian law, advances a claim, which in the light of the nature of that claim justifies, for the sake of argument, a conclusion that the issue is properly to be characterized as an issue of succession, which then leads to the selection of the appropriate English conflict rule, which actually may point to a law other than Brazilian law. And what that means then...
You're potentially into renvoi, aren't you? So sort of half remember.
Well, no, but I think all I'm saying is it often happens that a claimant makes an assumption as to what it thinks the applicable law is, formulates a claim which gives rise to issues, but when it comes to the court's resolution of the debate as to what the applicable law is, obviously the court may come up with a conclusion as to what the issue is and what the conflict rule is that will then point to a different law. Now, that does not mean, the mere fact that the end result may not happen to coincide does not mean that the process of characterization has been falsified in some way, because the court has still identified the issue in a very broad way, having regard to the relevant legal concepts in play, and not necessarily treating itself as being constrained by how English law would regard the dispute or the relevant notions. That's all that's involved.
But I thought you said that the issue is, or the cover issue is, the issue is the authority of the individual to represent the estate. That's what I wrote down.
No, that's precisely what I didn't say.
Sorry, then
I think that's the point you were putting to me. What I said was the claims are not advanced by the claimants.
You said the heirs are claiming in their own right, and the issue is the authority of the individual to represent the estate. And you say, if you look at Brazilian law, they do have the right to represent the estate because they own it. They own the shows of action. That's what I thought you were saying, but it's not that.
No, it's
Oh,
like
right.
the issue in my respectful submission is not about authority.
What is the issue? What is the issue?
The issue is
law that will tell us the answer to the issue, but what in your submission is the issue?
the issue in my submission is whether the heirs are entitled to sue on the deceased person's causes of action as if they were the owners of those causes of action, just as the deceased persons themselves would have been entitled to do had they remained alive. Because that is how they claim. They claim like any other claimant on those causes of action. There's no distinction between an heir or a non-heir for that purpose. And when you appreciate how the claim is advanced in that way.
The question is, do they have title to sue?
Yes. Do they have title to sue? I would add, as the owners of the causes of action.
But does it matter whether you add as the owners? Because the English court can only grant relief to a claimant if the claimant has title to sue, if the cause of action is recognised by the English court as vested.
No, at this stage, you're not into that. You're simply about characterising the issue at the moment. You haven't got to the point of identifying what will be the conflict rule, and on the back of that, what will be the applicable law, because only then the applicable law will tell you what the court can or can't do.
Yes, but this is the point. I'm quite happy for you to reformulate it, but the question is, do they have title to sue? That's the question, full stop. The next question is, well, that all depends. If it's English law, they don't have title to sue. If it's Brazilian law, and as long as we don't go into the details, they do have title to sue. And the question for this court is, which of those two do we apply? Now that we know that the issue is, do they have title to sue? You would say yes if you apply Brazilian law. Mr. Kenyon would say no, not if you apply English law. And which of the two do we choose? Well, why should it be Brazilian, or why should it be English for that matter?
Well, the choice is, the first choice is not a choice between Brazilian law or English law. The first choice is between the legal category.
Yes, we've done that, and we've agreed without any reference to any legal system on this planet. The relevant issue is, do they have title to sue?
But then you say you have to put it into a box. You have to characterise.
But you have to find a legal category for that. That is simply identifying the issue. It's not. It's not.
Well, then I think, since we're sitting in England, the English court has to ask itself, how do I decide whether the person who claims to be the owner of this shows in action is in fact the owner of this shows in action?
Precisely.
And you say, well, they are the owners, because that's what Brazilian law says. But Mr. Canelli says that the only way that you can prove ownership of an asset which belonged, an English asset which belonged to someone who's died, by producing to the English court some form of grant recognising that the asset is vested in you. And that seems to me to be the ambit of the debate. And at the moment, I am not clear why those can both be true. You can be right.
There can be multiple issues.
Well, there can be, but let's try it and confine it to this. You say, as a matter of Brazilian law, the heirs are the owners. Mr. Canelli, I think, doesn't dispute that that's what the Brazilian law says, but he says you can't prove you're the owners in England and claim title to English assets without producing a grant. Now, it may be that you can get a grant very easily. Maybe there are difficulties, but isn't that what we have to focus on? Can the English court recognise your ownership without having the grant in front of it?
No, No, that
think that's you?
that with respect is
not the question at
no,
all?
that is not the first question that arises, if I can put it that way. The primary question that arises in the context of claimants who purport to claim as if they are the owners themselves of the causes of action, a proposition that is denied effectively by the other side on whatever grounds. It doesn't matter. And in a sense, what you've identified just now is the ground upon which they deny that claim. Just as the claimants are relying on Brazilian law as the basis for their claim. But what I'm saying is, and this is the crux of the matter, the real issue, the issue that is thrown up by that debate, if you strip away the justifications that both sides rely upon, which are partisan and beg the question, which is often the case, which is why you see, for example, the warning against not simply looking at the formulation of arguments but by reference to partisan interests. If you strip away the particular bases or arguments or reasonings that the parties rely upon, you still end up with the basic question that is thrown up by this case, which is whether the heirs are entitled to sue as if they are the owners of the deceased person's causes of action. Because that is the claim that is being brought. That is the claim that the heirs are bringing, rightly or wrongly. And that can only itself be determined in due course.
Why does it have to be determined in due course? I mean, the issue of title to sue can arise at an interlocutory stage. If you can demonstrate that somebody doesn't have title, then the action shouldn't be allowed to go forward.
Sorry, by in due course, I think we're across purposes. By in due course, I don't mean that we shouldn't grapple with it now. What I mean is in due course in terms of the three-stage characterization process.
I thought you meant it had to go off the trot.
No, not at all. No. We have to.
You're quite happy.
We have to determine. You have to determine it now, or over the next few weeks.
Okay, I'll shut up in a moment. I'll just put one other example to you, and you tell me why it's different.
Yes.
Suppose instead of dying in Brazil, someone died in New York, and suppose the law of New York is, for practical purposes, the same as English law. If you leave a will, appointing your widow as your executrix and leaving your entire estate to her, for practical purposes, ownership of all your assets vests in her under the law of New York, because she's both the executrix and the universal legatee. And she brings a claim in England and produces the New York grant of probate. Can the English court give her any relief on the basis she is the owner of the causes of action? And I think the answer is not until she gets her grant resealed in England.
Well, the answer, according to Chetty and Chetty, I believe, is she can. And all that she needs to make sure is that she gets proof, she gets probate as proof of her title, but not as a fundamental prerequisite for the validity of her title. English law, I believe, and we'll probably see that in. I hope I'm not I think the only reason why I sound probably overconfident about this is because I was reading about it yesterday, but then I was reading quite a lot of cases. I may have got them all terribly mixed up, and this is not necessary.
I won't ask any more questions.
But at any rate, we haven't quite looked at the cases, but perhaps it might be convenient
to
look at least Vonkelin.
Yeah, absolutely. I'm not. We've blown you very much, of course. But,
well, I'm grateful. Look, there's no point in my making points that you have no interest in, and I think these are very important questions, so they need to be grappled with. But what I wanted to show you, I'm not going to show you Jennison because you know that very well.
That may be optimistic.
It is over 2 years ago. Well, let's start with Jennison then.
Oh, I see. Okay.
Jennison. So that's tab 53. And you can pick up the facts very briefly in paragraphs 1 to 6. Facts were a little complicated. But can I just ask you to refresh your memory and, as it were, just read paragraphs 1 to 6? Probably quicker that way. Forgive me. Then paragraph 13. So counsel who appeared for the defendants argued that while someone appointed as executor under the will of a testator domiciled in England and Wales obtains title to the estate on death, that is not the case with a testator domiciled abroad. The administration of assets of such a person in England and Wales is governed by the law of England and Wales rather than the law of the domicile, and under the former, a foreign executor will not be considered to have title to the testator's estate unless and until a grant of probate is obtained in this jurisdiction, or where this is possible, a foreign grant of probate is resealed here under the 1892 Act. Further, resealing does not operate retrospectively. In contrast, counsel for the claimant maintained that an executor can bring proceedings in advance of any grant of probate or resealing, regardless of where the testator was domiciled. The claimant thus had standing when this claim was issued. Supposing though that was not the case, the claimant acquired title retrospectively when the grant was resealed. As a matter of domestic law, an executor is considered to gain title as soon as the testator dies, but an administrator acquires title only when letters of administration are granted. And then there's a reference to William Clark, and then at paragraph 17, a reference to Chetty and Chetty. It is quite clear that an executor derives its title and authority from the will of the testator and not from any grant of probate. The personal property of the testator, including all rights of action, vests in him upon the testator's death, and the consequence is that he can institute an action in the character of executor before he proves the will. He cannot, and so this is the point I was making earlier to Lord Justice Nugee. He cannot, it is true, obtain a decree before probate, but this is not because his title depends on probate, but because the production of probate is the only way in which, by the rules of court, he is allowed to prove his title. An administrator, on the other hand, derives title solely under his grant and cannot therefore institute an action as administrator before he gets his grant. And then paragraph 18, which I think we can probably skim over for present purposes. And paragraph 19, in the case of a person domiciled abroad, the law of the domicile will apply in relation to various matters affecting the distribution of his estate. For example, testamentary capacity can be determined by reference to the law of the testator's domicile at the time of making the will. A will is treated as properly executed if its execution conformed to the internal law in force in the territory of the testator's domicile, and succession to the movables of an intestate is governed by the law of his or her domicile at the time of his or her death, including its choice of law rules. In contrast, a grant of representation under the law of a foreign country has no operation of itself in England. So, for example, I mean, there is obviously no issue in this case, as I said earlier, that any of the heirs claimants have obtained or purport to have had a grant of representation from the relevant Brazilian authorities. They just claim as in their own right as heirs. So in contrast, the grant of representation under the law of a foreign country has no operation of itself in England. The administration of a deceased person's assets is governed wholly by the law of the country from which the personal representative derives his or her authority to collect them. And there's a quotation from Preston and Melville. The domicile regulates the right of succession, but the administration must be in the country in which possession is taken and held under lawful authority of the property of the deceased. And then a reference to the distinction between title of executors and administrators, and essentially next to letter B, it has hence become a general doctrine of the common law recognized both in England and America, that no suit can be brought or maintained by any executor or administrator or against any executor or administrator in his official capacity in the courts of any other country except that from which he derives his authority to act in virtue of the probate and letters testamentary there granted to him. But if he desires to maintain any suit in any foreign country, he must obtain new letters of administration and give new security according to the general rules of law prescribed in that country before the suit is brought. And then 21, the need for a foreign personal representative to obtain a grant of probate or letters of administration in this jurisdiction was mitigated somewhat by the introduction of resealing as an alternative. And then on the facts of that case, the court went on to find that resealing did not here have retrospective effect. But if we go further to paragraph 31, we see the heading, the significance of Chetty and Chetty. In the claimant's case, however, that the appeal should be dismissed even if, as I consider to be the case, resealing does not have retrospective effect. Ms. Meager argued that the claimant derived her title to the claim against the defendants from the deceased's will, not from the resealing of the grant. Claimant, Ms. Meager, said needed either to have the grant resealed or to obtain a grant of probate in this jurisdiction in advance of the trial, only so that she could prove her title. Having been named as the deceased executor in his will, Ms. Meager maintained the claimant acquired title on death. She relied on Chetty and Chetty, and Lord Justice Newey concludes that over the page at letter B, the Privy Council thus appears to have applied the principle that an executor derives his title and authority from the will of his testator and not from any grant of probate in the context of a testator who had been domiciled in a territory different from that of the pending proceedings. And Ms. Meager argued that the present case is analogous. Like the executor in Chetty, she said the claimant derives the title from the deceased's will, as if she already had standing when the claim was issued in February 2019. Mr. Steer's response was that insofar as Chetty purports to decide that a person appointed as executor by a testator domiciled in one jurisdiction may institute proceedings in another jurisdiction before any grant or resealing of the latter. In the latter, it is contrary to principle and should not be followed, etc. And then reference to New York breweries. In New York breweries, individuals named as executors in the will of a testator domiciled in New York had been granted letters testamentary there. I think I need to read the rest of it because Lord Justice Newey then analyses what is said in New York breweries, and the conclusion of paragraph 38 is this, page 1438. In the circumstances, I do not think New York breweries can be taken as authority for the proposition for which Mr. Steer wished to use it. It seems to me to do no more than confirm that a foreign executor will need to obtain a grant of probate or resealing in this jurisdiction if he needs to prove title. All the Court of Appeal judges alluded to the importance of probate as a matter of proof. So in other words, adhering to the earlier position identified in Chetty and Chetty, that the obtaining of probate simply goes to proof, not to the inherent validity of the title. And then paragraph 41 There remains to be considered, however, the question whether the Chetty and Chetty approach is to be applied in relation to all foreign executors, or only where the law of the testator's domicile, like that of England and Wales, treats an executor as acquiring title from the date of the testator's death. It is quite possible that in Chetty and Chetty, the Privy Council knew or assumed that the law of British India was the same as that of England and Wales, and as might have been expected when India was part of the British Empire, might the position be different, where the law of the domicile is known to differ in this respect from that of England and Wales. The point matters in the present case because New South Wales law is not identical to English and Welsh law. And then I don't think we need to read the rest until we get to 47. And it so happened in that case, Lord Justice Newey found on the evidence, or having examined the relevant case law from New South Wales, the point on which the Australian judges diverge is not perhaps important for present purposes. What is noteworthy is that on any view, the law of New South Wales, unlike that of England and Wales, does not consider an executor who has not obtained probate to have legal title to the testator's estate. As a matter of New South Wales law, that is vested in the NSW trustee. It is therefore necessary to address the question whether the Chetty and Chetty approach is applicable even where the law of the domicile does not consider an executor to gain title on death. It is plain that if the Chetty and Chetty approach is applied in relation to the will of a testator who was domiciled in New South Wales, the court in this jurisdiction will potentially treat an executor as having title to the estate when a New South Wales court would not. And then 49, there is, however, no doubt that the English and Welsh law can diverge from that of New South Wales on whether a person appointed as an executor by a New South Wales testator has acquired title to assets in the estate. And then 50, as mentioned in paragraph 20 above, the administration of a deceased person's assets is governed wholly by the law of the country from which the personal representative derives his or her authority to collect them. It seems to me that the question, and this is the characterization your lordship placed or found in that case, it seems to me that the question whether the plaintiff is to be considered to have acquired title to the deceased cause of action against the defendants as the executrix appointed under his will, because that was the claim, of course, is properly characterized as one relating to the administration of a deceased person's assets. It appears to me, too, that notwithstanding that the claimant obtained a grant of probate in New South Wales, it is from this jurisdiction that she derives her authority to collect assets here. After all, a foreign grant of representation is not without more recognised as having any force in England and Wales. That being so, the law of England and Wales is, I think, to be applied to the issue of whether the claimant acquired title to the deceased estate on his death. In New South Wales law, on the point is immaterial. On that footing, the Chetty and Chetty approach is in point, and the claimant is to be regarded as having acquired title to the cause of action against the defendants on the deceased's death, and so as having had standing to issue the present claim, which she did. And the short point I make in relation to this case is that what was in issue was the authority of the executor, essentially, to act on behalf of the estate, pursuant to her appointment in the will. That was a case, essentially, where what was in issue was her capacity to represent the estate. And that was in the context of, obviously, her actions in connection with the administration of the deceased person's assets. She was not purporting to advance a claim in that case in her own right, beneficially in her own right, on the basis that she was the new, as it were, out-and-out owner of the relevant asset. She was an executrix. She could have been an administrator in a different case. And one can readily therefore understand in that case why your lordship characterized it in that way. The next case is High Commission of Pakistan. It's in the earlier bundle. tab 32. Pick it up at page 835. This appears to have been a CMC, essentially, in that case, where various parties tried to effectively be appointed as the representative of the estate of the seventh Nizam. If you look at paragraph 1, it seems to me, having read the material that I've been presented with, if I can ask you to read that, the context, the judge decides that Mr. Lintott should be appointed as the wholly, who was a solicitor, should be appointed as a wholly independent representative of the estate. And then the judge gives his reasons in paragraphs 3 to 5. I don't think those particularly matter for present purposes, but you can see that that was the issue in the case. And if you then go to paragraph 17, the judge turns to the representation of the estate and repeats his conclusion that Mr. Lintott should be the sole administrator. And then paragraph 23, it will be apparent from what I have already said that I'm not prepared to accede to Nawab Khan's application that he should be joined at once to the proceedings in a representative capacity. Insofar as he claims as an heir, he is, in my judgment, in the same position as all others interested in the estate as heirs. They can and should be represented at stage 1 by Mr. Lintott in his role as administrator. The Nawab can and should communicate with Mr. Lintott in relation to his own claim, or indeed any information which he feels can usefully be provided to Mr. Lintott. So obviously the judge was dealing with the best way to manage the proceedings in circumstances where he decided that the sole solicitor administrator was the appropriate way forward. And in 25 he says, I do not consider it appropriate to join Nawab Khan as a co-administrator with Mr. Lintott for at least 2 reasons, which he gives there. And then paragraph 27, which is the beginning of the passage that the judge relied on, I also need to deal briefly with an argument advanced by Mr. Brown this morning that the Nawab can claim directly against the fund in his position as an heir, assuming it to be established on the facts that he is an heir. The argument was put briefly that he would be able to rely on the Muslim personal law applicable to the succession to the estate. The evidence in its current and limited form indicates that his personal law would not recognize the concept of administration of an estate, and the relevant property would have vested automatically in his heirs. Therefore, the argument runs there is no estate for an English personal representative to administer, and nothing to prevent the Nawab from making a direct claim to the relevant property. That argument, it seems to me, is not sustainable on the basis of authority, which is both clear and binding on me under English conflicts of laws. The stage of administration of an estate is governed by the law of the place where the assets are situated, which in the current context means England. Procedural questions arising in relation to the administration are likewise to be dealt with by the law of the place where the administration is taking place. It is only when one gets to the question of succession and who is entitled beneficiary to share in the estate that one looks to the law of the domicile of the deceased. The disputed fund is situated in this jurisdiction, and then there's a citation from Willard, and the judge then goes on to say, I was also referred to a first instance authority in the BVI to similar effect, and to the decision of the House of Lords in New York breweries, and Attorney General. Both of those authorities, as a matter of fundamental principle, it seems to me the argument advanced by Mr. Brown is misconceived and does not provide an arguable basis for his client to claim directly in his alleged capacity as an heir. Now, it's not entirely clear from the judgment whether the argument of the heir argument, if I can put it that way, was being relied upon as a supporting argument in relation to Mr. Khan's appointment as co-administrator or for something else. But what I say generally in relation to this decision is this. First, the proper characterization of the issue raised by the heir argument under the Muslim personal law was not identified or addressed by Mr. Justice Henderson, whether by reference to Macmillan and Raiffeisen principles or otherwise. There simply appears to have been an assumption on the judge's part that because he was dealing generally with the administration of a deceased person's estate, with the relevant estate asset being a disputed fund within the jurisdiction, that therefore the issue of the heir's claim against the fund should necessarily be characterized as an issue of the administration of the estate. What is more, the judge's reference to New York breweries in paragraph 30, implying that he placed some reliance on it and that it somehow supported his conclusion, is very difficult to follow. As we know from Lord Justice Newey's explanation at paragraph 38 of Jennison, the only proposition that can safely be deduced from the New York breweries decision, which was in fact a tax case, where the question of representation arose in a very subsidiary manner. The only proposition that can safely be deduced from that decision is that a foreign executor will need to obtain granted probate or resealing in this jurisdiction if he needs to prove title. So that decision was not even about administrators, it was about executors who actually do acquire title validly under a foreign lex domicili. And it's very difficult, therefore, to understand that reference. But as I say, in any event, it would seem that the Nawab Khan's argument, based on his status as an heir, was being raised as an argument in support of his appointment as co-administrator.
Is that right? Wasn't if you look at 27, wasn't the argument Mr. Brown advanced that Nawab was an heir, therefore he could claim directly against the fund, which strikes me as indistinguishable from your argument, which is you're an heir, so you can claim directly against the defendants.
Yes, but
it's that which is rejected. So
yes, no, I on its face, and obviously I don't think that's in dispute. On its face, Mr. Justice Henderson's decision is against us. But
you say it's wrong.
I say it's wrong. The judge, with respect, quite apart from the fact that it's a very brief judgment, including as evidence, for example, by the reference to New York breweries, which is cited as an apparent authority in support of what he says earlier in judgment, which is suspect, to put it no higher than that. He doesn't actually grapple with the question of characterization.
Well, he does. He does in 29. He says, the authorities established that claims to property in this jurisdiction can only be advanced by and through a properly constituted personal representative. That's effectively saying, if you claim property in this jurisdiction, which used to belong to someone who is now dead, then that is to be characterized as an administration question, because you need to have a properly constituted personal representative. You can't answer that question simply by showing the succession question, which is who owns it. You have to show how can you claim it, and you can only claim it through a properly constituted personal representative. It may be short, but it's very clear what he's saying.
What I meant by he doesn't grapple with the question of characterization is not that he doesn't characterize, he does. But the point I made was that there was an assumption effectively on his part that it was appropriate to characterize the issue before him as an issue of administration, which in fact appears more clearly from paragraph 28.
You can see his categories from 28.
Yes, absolutely. I quite accept that it might be said against me, well, a very experienced judge.
As a CMC, he's not going to give a lengthy reserved judgment. He's giving oral judgments.
Or one might say it's a CMC and not necessarily a great deal of thought was with all due respect, was not put into it.
I'm not sure you would say that.
Well, I
Maybe
think
he thought the answer was so obvious he didn't need to spell it out any more than he did.
well, we can speculate, but I can only I think fairly judge it by reference to the content of the reasoning.
Your submission really is that 28 is just wrong. It's starting off in the wrong place. You're assuming there's administration and that succession is what happens when you divvy it up. But you say, no. Succession is the be-all and the end-all, or is at least the beginning, or is at least as good as administration. That's your real
or
case,
more
I
precisely, the characterization of the issue has
as
to be
administration is wrong.
is
A much
incorrect.
more high-level thing is to who gets to do this, and the answer is heir, not administrator in your analysis.
Yes.
And where we're going wrong is because we're English or Welsh, and we're thinking in this way because that's the way we do things. And you say, no, that's what we mustn't do.
Correct.
We must realise that
Correct.
it's access to the courts, and it could be just as much heir as administrator.
Yes, I mean,
your real case, you've just got it wrong.
absolutely. I mean, it's a fundamental peculiarity that in England, upon death, in a case of intestacy, it all vests in the public trustee. Whereas in civil law jurisdictions, it vests in the heirs. That's a fundamental difference, and this it's if we were if you were a French court and we were having this debate, they might well be scratching their heads as to, well, how on earth can English law treat succession as being only the stage at which, after a long period of administration, the court then decides how to divvy up, as it were, the assets, and all the stages up to that point are not succession.
It's tricky. This. I mean,
It is a bit
leaving
chicken
aside
and-
odd details, I don't think it's difficult for us to understand what the Brazilian approach is
Right.
to admit. I'm going to use to estates,
Yes.
and it's not a perfectly rational approach. It's different from our approach, but perfectly sensible approach. But then we have to decide, in English conflict terms, at what stage do you say it's a matter of succession? Is it different at an earlier stage?
Yes.
I mean, that is a different point.
It is a different point, and if I may say this, English law, in a broad sense, including its private international law branch, obviously recognises the concept of succession, not least because obviously we have Dicey's Rule 164. So when Dicey's Rule 164 says succession to movables will be determined by reference to the law of the deceased, the law of the place of domicile of the deceased at the time of death, one presumes that English law understands that that system of succession will obviously have its own content, its own rules, and that may not be different. That may not be exactly the same as English law. And indeed, the very reason why we have a private international law and why there are different conflicts of laws rules is because there is an assumption that the laws of different countries are different.
And I follow that, but I suspect that I can't remember the detail of Dicey, that the last sentence of paragraph 28 is pretty much Dicey.
Yes, I think when you are dealing with the authority of a personal representative to represent the estate, that is so, absolutely. And so that's dealing with representative title.
Well, it's not to point. I mean, what Mr. Justice
Oh, I'm so
Henderson
sorry. We made that cross purposes.
he says is when one gets to the question of succession and who is entitled beneficially to share in the estate that you're on to the law of the domicile. So it looks as though, and I think this is pretty much in line with Dicey, he's approaching matters on the basis that you put something into the succession box when you're concerned with who is entitled beneficially. And
Yes.
it's not actually what we're concerned with at the earlier stage.
But what is interesting, and this is the point I was going to ask you to reflect on, which is also made by Cheshire North, which is that even if you leave aside the peculiarity that under English law you have this extended administration stage with the statutory framework based on the public, the sort of, as it were, the deemed ownership of the public trustee. To leave that aside, when you get to the narrow English law meaning of succession, and you ask yourself, well, what is it concerned with? What is interesting is that even at that stage, or at that stage, it is concerned with beneficial ownership. And you see that, for example, well, I think arguably it's clearer in the passage in Cheshire North that's cited paragraph 189 of the judgment, where the authors address specifically the question of classification between administration and succession, and make the point at page 248 of the core bundle, paragraph 189. The judge quotes that passage as identifying the nature of the process. Administration concerns the procedure to deal with the deceased estates, including grants of representation, the representative's power to collect the deceased assets and pay debts, order of priority for payment of creditors, and the power of the representative to handle the deceased assets, such as postponing the sale. Succession concerns the substantive rights, such as the beneficial entitlement to the deceased's estate. And that's hardly surprising. I mean, just the very concept of succession implies the question, well, are you now the owner as a result, after death? There's nothing revolutionary about that proposition, and one might suppose that when Dicey Rule 164 has evolved over time, that when the conflict rule refers to succession, it has the question, it is focusing on the question of who beneficially owns the assets, not who is entitled to represent the estate of which this asset might form part, and may have powers of representation over it, but who beneficially owns it. And that I've spent an enormous amount of time discussing this point, but at the end of the day, all I am saying is, if you strip away the partisan sort of arguments that each side might advance, what is thrown up by the claim that's been brought, rightly or wrongly? And the issue, in my respectful submission, is, are these individuals entitled to sue on these claims as if they were their claims, just as the non-heir individuals are doing? If you look at it that way, where does the administration of the estate come in? Certainly in relation to the sole heirs, no question.
That would be my question. Certainly when it's more than one heir.
But it's instructive.
Even if they bring the claim and they win £1 million, they won't have £1 million in their pocket, because some of that £1 million has got to go to the other heirs.
But that is only because they are joint beneficial owners of the cause of action.
They probably don't have a concept of beneficial ownership in Brazil, I imagine.
They do. They have the concept of joint owners,
yes.
Which includes the benefit, all of the benefits that ownership brings. And I will show you that when we get to Brazilian law. They have the concept of condominium, which is another word for effectively collective ownership. The only distinction between absolute what you might call absolute ownership in a case where there is, as it were, no sharing process, is that you can do whatever you like with the thing there and then. But with sharing, you can do everything that anybody who is not subject to sharing can do. But what you can't do is you can't harm the indivisible whole. You can enforce it, you can enjoy it, you can take any steps that you need to take to protect it against third parties.
Could you settle it? Compromise the claim?
I think one would have to look at all of the list. I think certainly if you might be able to do some of those things.
That might harm your co-owners.
Well,
if you compromise it at 50% of its nominal value, they might say, no, you had a perfectly good claim. You should have taken it through to trial.
I entirely, and we'll have to go the minutiae in a bit more detail. There's no doubt insofar as there are some limitations. But the question is, does the existence of the limitations change the fundamental nature of the claim as a beneficial claim by those individuals, as opposed to a claim that is brought in a representative capacity, fundamentally on behalf of others, not dependent upon whether it so happens there's 2 or 3 or none of them, which is an incident of the nature of the deceased family and how big his family was, as opposed to effectively a legally different form of action that is being brought, because the person in question, the claimant in question, is a representative rather than a claimant in its own right. And obviously, I mean, under English law, there is obviously the concept of joint ownership. So, for example, CPR 19.3 deals with situations where there are joint owners. Joint owners are entitled to take action. The only requirement is that if they're not all joined, then there may be a requirement for, if they're not all joined as claimants, there may be a requirement to join the balance as defendants, so that the court can be sure that everybody is aware and is bound by the outcome. Conceivably, in this case, I suppose, a question might arise further down the road, whether if in relation to a particular deceased person, 3 of the heirs are parties, but the 4th isn't, the 4th and final heir isn't, assuming we can get over all of these other stages, that the court may require the joinder of that party, if that is considered to be relevant to the standing of the other 3. But that, in my respectful submission, would not change the capacity, if I can put it that way, in which the claim is being brought, which is that they are bringing it for their own benefit. Yes, they happen to be bringing it for the benefit of others as well, because for the time being, they have a share of an undivided whole. And as Professor Sanches says, the only way that a co-owner in that situation can protect his interest is by protecting the whole, because there's no other way. But that does not change the nature of the right as a personal right for himself, irrespective of whether he has consent of others. Anyway, I'll come back to that. But when you look at it that way, and that is the nature of the claim and the nature of the issue, it is much easier, in my respectful submission, to see how I suggest to characterize the issue that is being thrown up as an issue of administration is wholly artificial. It wouldn't be artificial. It would not be artificial if you start from the premise, I'm wearing my English hat, I'm looking at everything through my English spectacles, and for me, succession doesn't arrive until the final distribution.
And before we interrupted you again, you were going to take us to more authority, I think. Which other authorities do you think we need to see?
Well, I think Vonkelin is...
Yes. Should we do that before we
Yes,
break?
I think that would be very helpful.
I mean, in truth, is there any other authority that we need to see apart from Vonkelin?
Vonkelin, probably Haji Yanu.
Yes, I see. Yes, that makes sense.
Probably those 2 primarily.
Yeah. Well, let's do Vonkelin tonight anyway.
So let's. I'm very grateful, my lord. So Vonkelin is volume 2. and it's an interesting case. So can I try to, well, I think we should take it slightly. We should actually look at the facts, because there are some important distinctions. But I think we can probably get the facts from the judgment of Chief Justice Earl on page 463. So the thing to remember about that case, just to put it in context, is that there were two claims advanced by the widow of a gentleman who was domiciled in France, who basically was the drawer of certain bills of exchange, and who effectively found himself liable on that instrument to a certain Mr. Bolly, who was an endorsee of the bills of exchange. And what happened was Mr. Bolly got a judgment, essentially, on the bills for dishonor. Before that judgment was satisfied, essentially, the testator, the drawer died. Mr. Vauquelin died. His widow, under French law, was effectively the universal successor to all of these rights, including his rights under the bills of exchange. She paid the judgment after his death, and she then brought a claim based on the fact that she'd paid the judgment and had succeeded to Mr. Bolly's, the endorsee's, rights on the bills. And she also brought a second claim against the defendant, who was the acceptor of the bills of exchange. So there were two claims that she brought, two counts. So if we pick it up at page 463, upon the argument of these demurrers, several questions have been raised with reference to French law. The foundation of the litigation was certain bills of exchange of which the deceased, Mr. Vauquelin, was drawer, the defendant the acceptor, and one Bolly the endorsee. Bolly brought an action against both drawer and acceptor in the court of the Tribunal de Commerce of the Seine and obtained judgment against them. Vauquelin, the drawer, died. His widow, the now plaintiff, in accordance with the laws of France, became the donee of the universality of the real and personal estates belonging to the succession of the deceased at his death. And she alleges that thereby, and according to the laws of France, all rights, claims, and causes of action, and all liabilities and obligations of the deceased vested in her personally and absolutely, and she became, according to the said laws, liable personally upon the said judgment, and also entitled personally and in her own name to sue for and enforce all of the rights and claims of the deceased, and that she was, according to the said laws, substituted for and placed in the same position with respect to the defendant as regard the said bills of exchange, and the judgment thereon, as the deceased had been in his lifetime. The count then goes on to allege that afterwards, so that's after the death, and whilst the judgment was in full force and unsatisfied, the plaintiff and defendant were both liable thereupon. The plaintiff, in accordance with the laws of France, was obliged to pay and did pay the full amount of the judgment and all interest due thereon, and that thereupon Bolly delivered to her, so Bolly being the satisfied creditor, delivered to her the said bills of exchange and the record of the said judgment, and the plaintiff then became, and still was, according to the laws of France, entitled to the benefit of all the rights of Bolly upon the said judgment against the defendant, and entitled to enforce the same against the defendant, that to be substituted for Bolly in all his rights against the defendant in respect to the said judgment, and the defendant became indebted and liable to pay her the amount so paid by her upon the said judgment with interest. And then if we go over the page, pick it up at the bottom of about 10 lines down from the top, where it says, that is the substance of the first count. So the description that precedes that sentence is a description of the first claim, essentially, by the widow based on her payment of the judgment. The substance of the second count is that certain bills of exchange were drawn upon the defendant by the deceased and accepted by him and dishonoured, that the deceased died and the plaintiff was, according to the laws of France, the donee of the universality, and etc., etc. And then if we look after the marker for page 365, the said bills became vested in the plaintiff, and she became entitled to sue the defendant thereupon, in her own name and in her own right, and she demands payment of the amount thereof and interest. The ground of the demurrer to these two counts is that the plaintiff is in effect suing in a representative character, which she cannot do without having obtained letters of administration in this country. The allegation in both counts is that, being donee of the universality of the personal and real estate belonging to the succession of her deceased husband, the plaintiff became, according to the laws of France, entitled to all the property and rights of the deceased absolutely in her own right and not in any representative capacity. I am of opinion that that averment, if it were necessary to stand upon it, must be taken to be true, and so it appears upon the record that the law of France, in which country all the parties were domiciled, would give her a locus standi to sue there in her personal capacity. But it is not necessary to rest upon that. The first count shows that after the death of her husband, the plaintiff paid the amount due to Bolly in respect to the bills and the judgment, and that, it seems, would give her the right to sue in the courts of France in her own name and in her own right, as indeed it would in this country also. It has on many occasions been held that an executor or administrator has his election to sue either in his own right or in his representative character in respect of transactions arising since the death of the testator or intestate, although what is recovered would be assets in his hands. Here, the alleged cause of action is founded mainly upon what was done by the plaintiff after the death of her husband. There is a further answer to the demurrer, the demurrer to the first count, so it's still dealing with the first count, namely that the rights were confirmed by the second injunction or the second adjudication or injunction in a French court, which is irrelevant for present purposes. And then the relevant passage for present purposes, further down, 4 lines from where page 366 appears, as to the demurrer to the second count, so this is the claim based on the original bills of exchange, in no way dependent on post-death conduct. As to the demurrer to the second count, it is clear that the plaintiff took the bills on the death of her husband, and if nothing more appeared, she could only enforce them here by clothing herself with the character of his representative. But the law of domicile attaches to these parties, and there is a distinct averment that the plaintiff was, according to the laws of France, the donee deceased, the donee of the universality, and so on and so forth, a reproduction of the evidence about the Cézanne principles. I think, bottom of the page, I think it sufficiently appears upon this record that the plaintiff was entitled to sue upon these bills in her own right. The fact of her being the donee of the universality of the personal and real estates belonging to the succession of her deceased husband, giving her by the law of France rights different from those which an executor or an administrator has in this country. I'm therefore of opinion that the plaintiff is entitled to our judgment upon the demurrers to both counts of the declaration. And then, if we go to the next judgment of Mr. Justice Williams, he says, I am of the same opinion. As to the first count, he deals with the first count, but which we can skip over because that's the post-death transaction. If you go a little further down, the passage beginning about halfway down on the right, but that learned author goes on to say, goes on to say, and I agree with the qualification, that the rule does not apply unless the party is suing in right of the deceased. Applying those principles to the first count, it appears to me to be plain the right which the plaintiff is there seeking to enforce is not a right which the deceased ever had.
So can we jump over that?
So that's the post,
Yeah.
forgive me, that's the post-transaction claim. And if you go further down to after the reference to 372, these considerations do not apply to the second count. As to that, I must confess I feel some difficulty. But as my lord and my brother Keating have come to the conclusion that this count is capable of being construed in a way to which I will presently advert, I do not feel justified in differing from them, though I cannot help entertaining some doubt as to whether that is the proper construction to put upon it. There is no doubt that by the law of this country, property which a man takes as executor may be so dealt with by him as to become his own. This was established in etc., etc. And then a reference to the position with an administrator. Now here the second count contains an averment that on the death of her husband, the plaintiff was, according to the law of France, the donee of the universality of the person.
Can we jump down to just above the first hole punch? It says, now the construction of the rest of the court.
Exactly. Now the construction which the rest of the court put upon that is that it appears that the plaintiff has, by some course of conduct and proceeding which is not and need not be particularized in the declaration herself, become, according to the law of France, the owner of these rights and may enforce them by reason of her undergoing personal and individual liability in respect of them. I must confess I was strongly impressed with the notion that this was only a disguised averment, framed with a view to evade the rule which requires administration in order to entitle the party to sue in respect of the personal rights of property of a deceased person, but in substance amounting to no more than a statement that the plaintiff was the legal representative of her deceased husband. But I am disposed to assent to the view taken by my lord and my brother Keating, namely that it does amount to an averment that according to the law of France, the plaintiff, by reason of the liability which her relation to the deceased property entailed upon her, acquired a personal and individual right to enforce this claim, and need not clothe herself with the character of his personal representative. And Mr. Justice Keating then effectively expresses the same view in the first half of his judgment.
And there perhaps we should leave it. I'm sure we're behind.
We are behind, but I want to cut my cloth accordingly.
I'm just wondering.
Oh yes, that's fine for me. Yeah.
Would it help if we started at 10 o'clock on Monday?
That would be incredibly helpful.
And then I would still leave it to the two of you to sort out between yourselves how the time is divided.
Indeed, my lord. By our calculation, Moulder and Friends have 1 hour, and subject to starting it, if we start at 10:30, they would have 1 hour and 5 minutes left to complete this reply following my submissions on these grounds of appeal and respond to our ground 3, which remains to be argued. So there is very little time left.
Well, we'll start at 10 on Monday.
May I respond to the request that was made earlier in relation to undertakings?
Yes, please.
Just in case this is of use before the break. So what I can indicate is that and this is not intended to be a very precise form of words, but I hope it conveys the essence of what we're prepared to undertake. The claimants are willing to undertake that they will not rely on relation back under section 35(1) and will treat the pre-service amendments to the Viegas Claim form as being effective from the dates that the amendments were respectively made on the 22nd of November 2019 and the 23rd of January 2020, insofar as this is necessary for the pre-service amendments to continue to stand.
Yes, I follow. Fine, well, we'll break there at 10 o'clock on Monday.
Court rise available.